Welcome to the 2017 Evidence Midterm Review. We're going to be reviewing last year's midterm, so let's just jump into it. Question 1. All right, so I like to look at the call of the question first, so I'm going to be doing that for all these questions. Here we go. If the defendant's brother takes the stand and the plaintiff attorney seeks to question him about a prior conviction, defendant's best argument for excluding the evidence of prior conviction would be? Well, there are only a certain amount of ways that prior convictions can be out, and here's a list of them. First, looking at Rule 609, excluding prior convictions. If it's a witness, we can exclude it through the 403 balancing test. That's 609A1A for a witness who is not the defendant in a civil and criminal trial. 609A1B is for the unique balancing test, but that's another way we can keep it out. 609AB is convictions that are over 10 years old. They're considered stale and can be kept out based on that balancing test, the reverse 403. Then we have juvenile, pardons, and felonies versus misdemeanors. Generally, misdemeanors are going to be kept out unless they're crimes of falsity. So misdemeanors are limited, and felonies would have to work through these other items on the list. So we're looking for something that falls within these 6 items. So here's a question. Plaintiff, a cannabis farmer who sells medical marijuana dispensaries, or who sells 2 medical marijuana dispensaries, is suing the defendant for property destruction. Defendant crashed his car through one of the plaintiff's greenhouses at a high rate of speed, destroying thousands of dollars of equipment and grow lights. Settlement negotiations. Defendant says, look, I'm willing to offer you $10,000. I don't think I owe you anything because it was an accident. But I don't want to drag my younger brother, who was in the car with me at the time, into court. Ever since he got arrested a couple of years ago, he hates anything to do with court. The parties do not settle but go to trial. Before trial, plaintiff's counsel finds out that the defendant's younger brother has a juvenile record for stealing cars. So, if the defendant's brother takes the stand, and the plaintiff's attorney seeks to question about that prior conviction, that juvenile conviction, the defendant's best argument for excluding evidence of the prior conviction would be, well, it's a juvenile adjudication that seems to be on our list as number 4. Let's see if anything else is in these answer choices. A, plaintiff learned about the conviction during settlement negotiations. That is not even on our list, and so what? It's pre-existing. C, stealing cars is not a crime, which dishonesty or false statements is one of the elements. That's true, but if it's a felony conviction over a year, it can come in unless it fails in one of the balancing tests. So that does not work. And C, the younger brother is a witness, not a party, but 609A1A deals with witnesses and not the party to the lawsuit. So it seems that B is our best answer for 1. And yes, the answer to 1 is B. Question 2. Now, again, let's look straight at the bottom. Pat's best argument for opposing the motion to eliminate is that replacement of the walkways. That gives us nothing, so we'll go right to the question. Pat is a worker at Midway Processing, a processing and storage facility for liquefied natural gas. Envision Natural, a company that leases storage facilities at Midway, where the gas is loaded into Envision tankers. Now, Pat was injured when part of the walkway used by workers to monitor the Envision storage tanks gave way. After the accident, E&G retrofitted all of the walkways, added storage tanks with extra bracing. Now, Pat sues both E&G and Midway. In answering Pat's complaint, E&G denies responsibility, claiming that because it only rents storage facilities at Midway, Midway is completely responsible for the maintenance of the walkways and other structures at the facility. Pat learns about the retrofitting during discovery. So prior to trial, E&G brings a motion to eliminate to exclude any evidence that it retrofitted the walkways, claiming such evidence would be prohibited by subsequent remedial measures. So, Pat's best argument in opposing the motion to eliminate is that replacement of the walkways, : So subsequent remedial measures are not admissible to prove negligence, culpable conduct, defect in a product, or a need for a warning, but that is a very limited rule. Because The exception is for any other purpose, and it gives us some examples. Impeachment, if disputed, proving ownership, control, or feasibility of precautionary measures. Well, here, E&G is disputing control. They're saying Midway is responsible. So, since they're disputing ownership and control, it seems to lead us to a clear understanding that under the exception for 407, since control is being disputed, then this evidence should be brought in because it falls within the exception of 407. So B seems to be the answer. Is admissible because E&G's disputing control of the walkways. Now, let's look at the other answers. A, admissible to impeach E&G if E&G personnel testify at trial that the walkways were adequate and met all required safety standards. Well, let's say they do testify to that. Is that a prior inconsistent statement? Is that in some way bearing on truthfulness? Like, without more, how is this impeaching the witness? Is this a prior inconsistent statement? Is this a contradictory statement? We would need to know more to understand why it would be admissible to impeach. So I'm not sure if that's the best argument. It's not better than B for sure. B fits right within the rule, the exception of the rule. What about C? It's not a subsequent remedial measure. Well, it is textbook is a subsequent remedial measure. There was an injury. They retrofitted the walkways that would make that injury less likely. This is a subsequent remedial measure. C is incorrect. And D is admissible because the retrofitting is pre-existing evidence that Pat learned during discovery. That does not make sense. Not for exception to 407. So, the correct answer here is B. Moving on to question 3. Again, let's read the call of the question. Which of the scenarios below best supports attorney calling a character witness to attest that Wendy has a reputation for truthfulness? So, reputation for truthfulness. And now we have plaintiff attorneys calling a character witness to attest to someone's reputation for truthfulness. So that's bringing up 609. And 609 says that evidence for truthful character is admissible only after the witness's character for truthfulness has been attacked. That's 608A and the last sentence in that paragraph. In a civil personal injury trial based on an automobile accident, plaintiff attorney presents Wendy as a witness to testify that she was a passenger in a car, okay, and the plaintiff was driving within the speed limit at the time of the accident. So she's a fact witness. I was in a car and this happened. Defendant's attorney cross-examines Wendy. Okay, so he's cross-examining her after she's testified. Now, plaintiff attorney then seeks to call a character witness to testify that Wendy has a truthful character. Okay, so that means the defense attorney had to, during his cross-examination, attack Wendy's character for truthfulness. So, which of the following scenarios best supports the plaintiff's attorney calling a witness, a character witness, to attest that Wendy has a reputation for truthfulness? So, we now understand that if Wendy's character for truthfulness is going to be bolstered, it had to be attacked first. That's Rule 608A, last sentence. Must be attacked, then you can rebut by bringing evidence that she has a truthful character. So, we need some facts that lead us to establish that Wendy's character was attacked on that cross-examination by the defense attorney, and by attacking her character for truthfulness, we can then rehabilitate with another witness to attest that Wendy has a truthful character. So let's evaluate the answer choices. A, if the defense attorney establishes that Wendy is a plaintiff's sister-in-law, that shows bias and does not attack Wendy's character for truthfulness. It may show Wendy has a bias, but it does not attack her character for truthfulness. And since that answer does not attack Wendy's reputation or character for truthfulness, that answer choice is wrong. What about B? if the defendant's attorney had impeached Wendy with a prior inconsistent statement that went to a non-collateral matter. Well, you can bring extrinsic evidence in, but again, this does not attack Wendy's character for truthfulness. Why? Because a prior inconsistent statement does not have to bear on someone's truthfulness. It does bear on credibility, as we learned before, but it does not bear on the person's character for truthfulness. Credibility, yes. Truthfulness, no. So that is why B is incorrect. And C, subsequently, is also incorrect because it says the same thing, except it plays with the non-collateral and collateral matter. The fact that someone has made a prior inconsistent statement doesn't bear on their character for truthfulness. It does bear on their credibility, though. And D, if the defendant's attorney had impeached Wendy with the prior conviction. Hold on. That seems odd, but let's look at the rule. Rule 609. If I'm impeaching someone by evidence of criminal conviction, 609A says, in general, the following rules apply to attacking a witness's character for truthfulness by evidence of a criminal conviction. So, if the defense attorney attacked Wendy's character for truthfulness with the prior conviction, the defense attorney had impeached Wendy with the prior conviction, then he's attacked her character for truthfulness based on Rule 609. And by doing so, that would allow the plaintiff's attorney to call a witness to rehabilitate Wendy's character for truthfulness which was attacked. So the correct answer is D. Question 4. Plaintiff academic sues defendant professor for defamation. Hold on. I just went right into the question. I should be reading the call of the question first, which is the court will most likely. That doesn't give me a lot, so I'm back up front top. Plaintiff academic sues defendant professor for defamation based on the posting of defendant's widely read blog, and plaintiff is a know-nothing who should not work at a major university. During defendant's case in chief, witness testified that plaintiff's reputation in the academic community was very poor and that his papers are considered weakly researched. Witness further states plaintiff hasn't had a peer-reviewed paper accepted in a major publication for 15 years. So, plaintiff's attorney then objects to the last sentence and moves to strike, arguing that, hold on, this is a specific act to prove character and is not allowed on direct examination. So, we're looking at 404. We're looking at character evidence again. And here, remember, character evidence is generally barred, 404. But methods of proving character, 405B. Under this exception, by specific instances of conduct, a person's character or character trait is an essential element of a charge, claim, or defense. The character trait may be proved by relevant specific instances of the person's conduct. So in this case, this is a defamation suit. That means somebody's lying. That means your character for truthfulness is an essential element, charge, or defense. If you're a liar, that's what defamation is about. Someone is lying on me. Somebody's defamed me. So, since this is a case on defamation, we're looking for the answer choice that goes to that exception, 405B. And C, overruled the objection because this is a defamation case, and the character for truthfulness is an essential element to a defamation case, so the answer is C. Let's evaluate the other answers. A, sustain the objection because the rules limit inquiry of specific acts to cross-examination. No, 404B is the exception. It's a defamation case. B, sustain the objection unless the plaintiff had opened the door. No, plaintiff doesn't have to open up the door. This is a defamation case, and the character is an essential element of the charge. What about D? Overrule objection because it goes to the plaintiff's habit or routine. Well, we don't really have any evidence of that. So it seems like C is the best answer. Let's go to question 5. Reading right to the call of the question, the prosecutor has a good faith belief that the defendant participated in a sham or false marriage 4 years ago in order to help a friend with their immigration status. In cross-examining the defendant, the prosecutor does what? Well, I'm going to read the rest of the question. The defendant is on trial for conspiracy to import or distribute a controlled substance. The defendant has taken stand and denied all knowledge of the conspiracy to distribute a controlled substance, while acknowledging knowing the other co-defendants. So, we're at 608, and we're talking about, we have a specific instance of conduct, which is the sham marriage, and we're trying to figure out if the prosecutor, who has a good faith belief, can ask this question, and what else can the prosecutor do when this is put forward. So, 608 allows the prosecutor to ask this question. 608B, last sentence, but the court may, on cross-examination, which is what's happening here, allow specific instances of conduct to be inquired into if they are probative of the character of truthfulness or untruthfulness. So I would say participating in a sham marriage 4 years ago does bear on truthfulness or untruthfulness. But we also have to remember this. If you want to bring extrinsic evidence to prove this sham marriage, you then have to make sure that it is a non-collateral or material matter. See, if it's a collateral matter, then you can't bring in any extrinsic evidence, but the person can ask the question. Remember, I can ask the question, but I'll be stuck with the answer. But if it's a non-collateral matter, if it's material to the charge, then I can bring in extrinsic evidence to prove that. So, this seems like, under our evaluation, the prosecutor can ask about the sham marriage, but will be stuck with the answer because the charge or claim here is import to distribute a controlled substance, and participating in a sham marriage is collateral to that. It's a sideshow. It's not material to this trial. So, it's unlikely that the prosecutor will be able to bring extrinsic evidence to prove this, and he or she would be stuck with the answer. So let's evaluate the answer choices. A, cannot ask? Oh, no, wrong already. We know he can ask. That's what Rule 608B says. Cannot ask? Okay, again. Cannot ask? Can ask. What about C? Can ask about the false marriage? Yes. Can offer extrinsic evidence because it is an act showing the defendant has a dishonest character? No. It has to be material. If it's material, then you can bring extrinsic evidence. You can't bring extrinsic evidence just because it shows he has a dishonest character, which this may do, but it's a collateral issue. And you can't bring extrinsic evidence to prove a collateral issue. We don't want to have trials within trials. So C is incorrect. So D, can ask about the false marriage? Yes. But cannot bring extrinsic evidence? Yes. Unless they are able to show the marriage is relevant to a fact of consequence. And that is true. So, this says that we can ask about the marriage, but we can only bring extrinsic evidence if it's material. And that's what relevant to a fact of consequence. Question 6. So let's go back down to the bottom. Upon appeal, okay, the court will most likely. So let's just go right into it. In a murder prosecution, the prosecutor shows the defendant 12 gory autopsy photos of the alleged child victim during plea negotiation conference. Wow. After looking at the pictures and discussing things with his attorney, the defendant offers to explain how the child died if the prosecutor agrees to allow him to plead to manslaughter. After much back and forth, the prosecutor refuses to drop the first-degree murder charges and goes to trial. At trial, the defendant's theory of the case is that the child was not murdered, but the child fell to his death, and the defendant in a panic buried him and left the state. Over the defendant's objection, the trial court admitted 7 autopsy photos into evidence, finding them to be relevant. Oh, I'm sorry. Let me reread that. The trial court admitted 7 of the autopsy pictures into evidence, finding they were relevant to oppose the defendant's claim of accidental death. Trial judge excluded 5 other photos, finding them overly prejudicial and repetitive. So we have to understand a couple of things. This is going to our review because we're on appeal. And trial judges have immense amounts of discretion when making these judgments, when making these determinations between prejudicial and probative. Now, unless it's something really, really crazy, the trial judge's decisions are pretty much going to be upheld. Remember, we're talking about something that's going to change the outcome, something that's just so crazy. Remember those standards that we were talking about when we were talking about upon appeal. So, we're looking for an answer that seems seemingly going to uphold this ruling without any more information. Because if this is all we have, then it's going to be hard for an appeals court to overturn it. Let's see. First, A, reverse the trial judge's decision because the photos discussed were in a plea negotiation conference. No, that doesn't matter. You got to remember that rule. That if just because they were discussing plea negotiations doesn't make them not admissible. Reverse the trial judge's decision because the photos were prejudicial. Okay, they were prejudicial to the defendant and likely appeal to the jury's motions. Well, don't forget the trial judge has a lot of discretion, so even if that's the case, that wouldn't be enough to reverse. Remember, to reverse is a pretty high bar. Affirm the trial judge's decision because the trial judge is entitled to great deference, which is true, on balancing probative value and unfair prejudice. Yes, C is a perfect answer. And D, affirm the trial judge's decision. Yes, we agree that it would probably be affirmed if this was all we had, because the evidence depicted in the pictures is relevant. Well, if it's relevant, that's great, but don't forget you also have other relevance isn't the bar to let things in. You can't, just because it's relevant doesn't mean it's going to come in. There are other things that could keep it out, and the prosecutor is entitled to tell the story as they wish. No, they can tell the story as long as they're following the rules of evidence. So, the best answer in this is C. Question 7. Plaintiff's best argument to have the evidence admitted. So we're trying to admit some evidence. So let's read it. Plaintiff is a prisoner suing defendant as Zach County Sheriff for discriminating by forcing the plaintiff to remain in solitary confinement based on plaintiff's sexual orientation. Yeah, you have a case. Defendant sheriff calls Winston. Okay, Winston, one of the guards at the facility, who testifies that the plaintiff requested to be housed in solitary confinement out of fear of assault from other prisoners. On cross-examination, plaintiff's attorney asked Winston, "Isn't it true the county recently determined you lied on your timesheet and improperly received over 100 hours of overtime in the past 6 months?" Winston answered that he did not lie, but there was a misunderstanding. There was a misunderstanding with the hours he thought he had been assigned. Hey, it was my mistake. Plaintiff's attorney then asked, "Isn't it true that the county supervisor issued a report strongly suggesting the sheriff fire you for your actions, but the sheriff only issued you a warning?" Winston replied, "The supervisor doesn't know what it takes to be a prison guard. Ask the sheriff. He knows how hard we work." So then the plaintiff then seeks to have a copy of the supervisor's report admitted into evidence. Defense counsel objects, arguing it is inadmissible extrinsic evidence. So, we have here an issue where we want to get some extrinsic evidence in, and we know to bring in extrinsic evidence, the matter has to be a non-collateral matter. It has to be material. So, let's evaluate this. Here, the county supervisor strongly suggested the sheriff fire Winston, but he did. He only issued him a warning. Now that's huge, going from being fired to just getting a warning. So it seems that Winston would be biased toward the sheriff for doing something so wonderful as saving his job. So as we know from class, if you can show a witness's bias on collateral, that is always material. And as a consequence, you can always bring in extrinsic evidence to show bias. So we're looking for the answer choice. that allows us to bring in this evidence because it shows that Winston has a bias. C, the evidence shows the witness is biased in favor of the sheriff. Why? Because showing a witness bias is always material, and no extrinsic evidence is allowed to show bias. So let's look at the other answer choices. A, the evidence is admissible only if, well, not only if. It's admissible if you're trying to show bias, but it includes prior consistent statements of the witness. No. Because let's say that's true. Let's say if A is true. Of the witness, if you bring extrinsic evidence, it still would have to go to a non-collateral or material matter. If it's going to a collateral matter, then it wouldn't be able to be brought in. So A is wrong on the law. B, evidence is admissible only if, I hate only if, it is not extrinsic but pre-existing. I don't know where this came from. That is not even a rule. That is just a statement. And D, the evidence shows the witness has an untruthful character. But again, even if it did, the only way you could bring extrinsic evidence if it goes to a non-collateral matter. And again, for D, you generally can't bring extrinsic evidence to show untruthful character under 404. Question 8. Petty, who runs the exotic fish store, fish and aquarium store, is prosecuted for illegally importing exotic fish without the required licenses and permits. The charges require the government to prove that Petty intentionally circumvented the regulations when importing fish. Petty's defense is that she did not intentionally fail to secure the proper licenses and permits. She just overlooked some very detailed regulations innocently, missing some paperwork. So, Wendy, one of Petty's employees, testifies for the defense that she worked for Petty for 10 years, and Petty is scrupulously honest in all her dealings with employees and customers. So, Petty is honest. That's what the witness testified to. Character witness. On cross-examination, prosecutor seeks to ask Wendy if Wendy knew that Petty has recently been charged with possession of a kilo of marijuana. But what does being charged with a kilo of marijuana have to do with honesty? Let's look at Rule 404. It states that 404A2A, a defendant may offer evidence of the defendant's pertinent trait. So the defendant here is offering evidence from Wendy's testimony that they are scrupulously honest. And if the evidence is admitted, Wendy's on the stand, she's testifying, the prosecutor may offer evidence to rebut it. So, since the prosecutor can offer evidence to rebut honesty, how then does this evidence go to honesty? How does being charged with the possession of a kilo of marijuana, how is it pertinent to honesty? It is not. So this more than likely will be objected to, and the court will more than likely not allow it. So, let's evaluate our answer choices. A, possession of marijuana is not conduct pertinent to honesty. I like it. Let's look at question B. The question is unduly prejudicial. Well, that is a statement, but it's not the best argument. A better argument is that it has nothing to do with honesty. C, the prosecutor is inquiring about specific instances of conduct, which they can. And D, Petty has only been charged, not convicted of possession, but again, that doesn't have anything to do with it. You have a witness on the stand testifying to truthful character, and the prosecutor can rebut it, and they can rebut it, but here the prosecutor is not rebutting it, it's bringing in some other evidence which is not pertinent to the character trait of honesty. So here, A is the answer. So listen, everyone, I want to thank you guys for watching this video. Later on tonight, I'm going to put up the video for the essay portion of the questions, and I hope this was helpful. If you have any questions, comments, or concerns, send me an email. I'll be in school on Sunday. from about 12 to 4. So I'll see you then if you're going to be by, and if not, good luck on your exam.